Welcome back. I'm sorry that we aren't able to meet together personally today for class, but certainly hope that you're staying safe, staying warm, and enjoying the time off. In order to keep on track with the content, I'm going to go ahead and give you this video as a way to keep on track and to finish up our content with Chapter 5 on intellectual property. And the way we'll do this, I'm going to give you some introductory remarks. We'll pick up where we left off with last Thursday, and then I'm going to splice in a recording from last semester which covers this same information, and so you may notice when that transition takes place, but just so you understand, that's what's going on. Then on Thursday we will have our test on chapter number 5 in class, and you can bring with you your review questions that were due on Tuesday, and just bring a hard copy of those along with your chapter 6, your cases for chapter 5 and your review questions for chapter 6, both on the same day there on Thursday. We'll just bring them all together. Okay, so we left off on Thursday talking about trademarks, and we talked about the fact that intellectual property involves any property that is the product of an individual's mind. For example, books and software, movies, music, anything that can be produced and reproduced can be protected as intellectual property. And we talked about the fact that that is a constitutional origin to that. And so that's a very key, distinct American concept. And over the years, the original fundamental reason and basis for that has been eroded a little bit as it's been expanded to include protecting the business interests of those. And to some extent, you can see that that's necessary, right? I mean, if we don't protect the ability for someone to make money from their inventions or the things that they create, then there's less incentive for them to do that. And so the business side of it has grown exponentially over the years, so that there's a little less emphasis on the promotion of science and the useful arts, and a little less on that and more on the business and the financial aspects. And so we've seen over the years that that has taken place to some extent. Now, there are three basic elements to intellectual property. We see trademarks, and then we see copyright, and then we see patents. And those are the things that we're going to talk about as we go through the materials again today. Now, last week we looked at trademarks as a distinctive motto, mark, or emblem that is stamped or affixed to a product so you can identify it in the market. And because of the fact that trademarks have to do with marketing, has to do with the identity of a product, then in those situations it's the consumer that we're trying to protect. And so what we're trying to do with that is make sure that we are not letting one company pass itself off on the goodwill of another company. And so we looked at the Coke versus Coke case, where the court said ultimately that Coke with a K cannot use that mark even though it's not spelled the same way, because that would create a substantial confusion in the marketplace. So how do you protect a trademark? Well, the first way that you can do that is through trademark registration. And in that case, a mark can be registered if it's either already in use or you are about to put it in use. You can't really register a mark and then never use it. You can register it, and then you need to either use it or you're going to lose it. And so you have to use it within 6 months in order for that to be protected. The second avenue that you have is if you decide not to register, which is where you get the little circle R, you could instead just do the poor man's trademark and just put the little TM next to that logo, just to give notice that this is a unique name or product name that you are going to use in association with your company. And that will protect it to some extent, just not quite to the same national extent that a registration does. This is all federal. You go to the U.S. Patent and Trademark Office website and you can register those trademarks. Trademark infringement, then, is what we call anyone that is going to either unintentionally or intentionally copy a mark and use that without authorization. And so that's kind of the broad definition that gets applied here by the U.S. Patent and Trademark Office, which is the office that receives those registrations. And so if you file, if you register, this is what gives notice to third parties, and you can renew that between the 5th and the 6th year and after the initial registration, and then every 10 years after that. So if you're looking in your notes, how long do these things last? Well, a trademark registration lasts 6 years, but it can be renewed, and then once you renew it, you get a 10-year renewal, and there's really no limit on how long you can continue to renew it as long as you are still using it. And the same rules always apply to the use factor. And so the only trademarks that they allow to be registered or protected are those that are distinctive from any kind of competing trademark. If it is distinctive, then it can be protected. And so you want to look in your textbook, for example, on page 146, there's a very good distinction, there's very good discussion of that I would recommend that you go ahead and check out. Infringement, then, requires proof that consumers are likely to be confused by this unauthorized use of the trademark. So, for example, if a spoof is done, this is where somebody takes a trademark and they use it in something that is obviously not by that company. And then you have to ask yourself, is there any likelihood that someone is actually going to be confused that that is done by the company itself? If the answer to that is no, you're not going to cause consumer confusion, then you're probably just fine in order to do that. And so if there is no commercial impact on that company, even if they're upset with you, even if it's not authorized, it's still legal. And so in order for there to be a claim for trademark infringement, you must show proof that there is a likelihood of consumer confusion. And so in order to have a very strong mark, let's just take a step back for a minute and say, what is it that's going to help make this to be a strong trademark? Well, let's say that we sell faucets and we're going to make our trademark be the faucet company. Is that a very strong mark? Is that a mark that's going to be easy to protect? Well, of course not, because it's just descriptive. It's not unique. It's not strong. A strong mark is something fanciful, something that has really no logical connection necessarily to the company or to the industry, and that's not going to simply just use descriptive terms. And so things like Amazon.com, that is an incredibly strong mark. Why? Because it has nothing to do with selling books online or selling stuff online. The only reason you have in your mind a connection between shopping and the word Amazon is because of what that company did. And so that's a very strong mark. Same with Yahoo and Google and Bing, I guess, and some of these companies that you see that use words that just mean nothing, honestly nothing really connected, and they were the first ones to do it. So a strong mark does not use generic terms, does not use terms that are already associated with the industry. And so it's kind of interesting when you see in an area, you know, Bob's Plumbing Supply, okay, great. You know what? That's not a very strong mark. But then again, he doesn't really care about having a strong mark because he's not a national brand. And so you have trademark infringement if there is a likelihood of consumer confusion. Now let's stay in the faucet industry, and if you know anything about that industry, one of the strongest companies in the plumbing and fixture market is called Delta Faucets. Delta is the name of the company. Well, is there any likelihood of confusion for Delta Faucets to use that terminology of Delta versus the other famous Delta, which is what? Delta Airlines, right? And so Delta Airlines versus Delta Faucets, could that be a lawsuit? Could one say to the other, we were using this first, you have to stop? Well, because there's no likelihood that consumers are going to mistakenly book an airline ticket when they were trying to buy a kitchen sink faucet, I don't think that we're going to have any problem with trademark infringement. Now, there is a new kind of lawsuit out there, and I'm saying new because it hasn't been around for as long, and that is called trademark dilution. And trademark dilution takes place when someone's behavior or activity diminishes the distinctive nature of an existing trademark. And so dilution actually does not require proof that consumers are likely to be confused. Instead, what you're saying is we previously had a very strong, identified, distinctive mark, and now because of this, people are now confused. They no longer associate that mark with our product and our company, and so you have diluted the value of our intellectual property. And so in this kind of situation, there is not a requirement that consumer confusion be shown, and the products involved do not even have to be similar. And so non-competitors can be charged with trademark dilution in a private lawsuit. Now, I got to be honest with you, personally, and there are a lot of legal commentators that agree with me, we do not view trademark dilution as a very good legal principle at all. And dilution leads to all kinds of trolling, which is what we call it, when companies simply try to put someone else out of business, or they try to use it to silence their detractors. And so, again, protected speech, saying things that are true, even if they're negative about a company, that's not going to get you charged with trademark dilution. But there have been cases where you see those side-by-side commercials, and somebody will say, okay, which one do you prefer, Pepsi or Coke, and they actually name names. Well, you couldn't ever bring a trademark infringement claim on that, but now people are starting to wonder about trademark dilution could possibly be charged there because the elements are so low. There's so little you have to actually prove. And so that's the basics of trademark law. Now, the distinctiveness of a mark, a strong mark is something that is fanciful, kind of arbitrary, and it doesn't necessarily automatically relate you to the product. So it has the benefit of being very strong in that way. What's the downside, though? The downside is you have to carry all the water on actually making that mark be associated with your product. And so that you have to spend a whole lot of marketing money on getting in the minds of the consumer that when they hear the word Xerox, you're talking about a copier. And for you, that's second nature. You were born knowing that. But back in the day, what is a Xerox? That's a word that was made up. The same with Starbucks and things like that. They are now synonymous with the industry. But in the beginning, it was only because of that company and the marketing that they did that's ever been the case. Now, a strong mark is one that you want to try to go for, but it costs more to try to get that advertising to be effective. Now, as we talk about the distinctiveness of a mark, some marks have a secondary meaning. That means they're descriptive, they're geographical, they use personal names, but they are not being used for that way. So things like London fog, okay, well, London has been famous for having fog, for centuries. It has nothing to do with overcoats, right? But what you're doing is you're taking something that was already famous for something else, and you are now applying it to your product, which has nothing to do with the original reason that it was famous. And so London fog is a pretty good example of something that existed, but now it's being used in a different way, in a secondary way. And so those can be protected if they have an association now with a product. But if you just try to go in and trademark the word college, well, I'm sorry, but there are too many people that already use that term, sir. You can't trademark that. Now, generic terms, there is no protection. And so this is obvious. You can't go in and trademark bicycle or computer or any of those kinds of things. But what becomes interesting is when a brand name becomes so synonymous with an industry that it actually becomes a generic term and loses its trademark protection. And that actually can happen in some situations. The most famous example of that really is Kleenex. When you say, bring me a Kleenex, you really don't care if it's Kleenex brand. You're just saying, give me a nasal tissue. But no one says nasal tissue. That's just disgusting. And so generic terms don't get protection. And the interesting situation is kind of that reasonableness test of when does something that used to be a protected trademark enter into the public domain and become a generic term. All right, so cyber marks is not a real word. It's just a made-up word. One that's not up here that I have a question for you on, just to kind of think through. What about search terms? So is it ethical to purchase your competitor's trade name as a Google AdWords search term? So some of you in marketing have done some of that, right? You've done some AdWords and stuff like that. So what do you think about the ethics of that? Let's talk first about the legal side, okay? Do you think that that should be illegal? Who wants to make the case? Who will make the case that that should be illegal? Just straight up trademark principles, okay? So you're using our trademarked name in commerce to promote your product and create confusion amongst consumers. Sounds like exactly the definition of trademark infringement, right? So straight up trademark law would seem to apply with that. Who wants to make the argument that it should not be illegal? Fred, you look like you're ready to make that argument. So you're saying the consumer is savvy enough to know what he searched for, and that this is not the same thing. And so as long as the website that pops up isn't intentionally trying to continue the confusion process. So if I'm Reebok and I buy all the Nike search terms, and whenever the search comes from that site, I make my site look like a Nike site, and I have their symbols and logos all over the place. It's just a little bit different. The Nike swoosh curls a little bit at the end, and so we say that's totally different. Or we have our slogan is very close to just do it. What is it again? It's very close to just do it. I don't know. We've twisted it somehow, right? And so. Or it just says do it everywhere. And so at that point we are trying to confuse, right? So that's going to be illegal. But if we're not doing that, and when they land on our page, it's clearly the Reebok website, what difference does it make? I mean, we get search terms all the time that you don't click on, right? I mean, how many pages deep in a Google search will you go before you say, I didn't search for the right thing, I'm going to go back and change my query? Do you how many of you ever even look at the second page? The second page. Do you ever even, okay, whoever goes to the third page just as a normal way of, I never go to the third page because by that time I figure, well, you know what, I could tweak my search and make this a little bit more specific and try to get what I want. Or I figure no one's ever had this problem before. And so that you just don't do that. So it's got to be on the top of the first page. And that position is highly coveted, right? I mean, that first search position is highly coveted. But when you're searching, there's lots of options. And so the question is, should that be illegal? All right, let's flip over. Is it ethical? Is it ethical? So let's say, yes, it is legal, okay, in the sense that there hasn't been any law that has come across and said specifically, yes, it's illegal. There have been a few cases, but the cases go either way. And that's the truth. Okay, the cases go either way. Some states say yes, it's infringement. Some states say no, that's just fair market stuff. So let's say it's not clearly illegal. What about the ethics of it? What do you think? Well, if you're the other company, do you have a fair opportunity to buy them yourself? Well, does anyone understand how these are purchased? How the pricing is set and how these actually are purchased? Haven't you guys gone into that? Mm-hmm. Yeah. How do you purchase an AdWord?
Basically, said how much you want to pay per click for that search term. At least in Google AdWords, the way I did it. I don't know if there's anything.
Oh, you get to just name your own price. It's like Priceline. You just say, I think I'll pay $1 for this.
And based on how much you pay for it, it'll go higher.
But why are some words more expensive than others?
Because they're used a lot.
So who decided that? Oh, okay. So if we just said you automatically get your trademark, then it'd be real cheap, right? Because there couldn't possibly legally or ethically even be competition for that word. Does that sound like market manipulation to somebody? It sure does. Okay. So if you're making the argument that it's an unethical practice because it's purposefully creating confusion and that sort of thing. You're trying to poach somebody else's traffic intentionally. But the other side of the argument would be it's a free market. If you want to buy it and it's that valuable to you, then bid me up. I bid $5. What's it worth to you? 6, 7, 8, 9, 10, 11. We'll go up. See, I'll finally hit my breaking point and you'll have to pay more. So win-win for me because my competitor just spent more on advertising. Okay. If I actually get it, I win on that too. So that's what the free market's all about, right? Finding those kinds of solutions. If you're Google, which way do you want it to be? You want it to be trademark owners locked down to their trademarks and no one else can buy them? No, you don't. You want massive competition, okay? You want everybody bidding on that stuff. Drive that price up because you get a cut, all right? Actually, you get all of the revenue. So understanding that dynamic, I had a client that is very good at using, I was going to say manipulating, but using Google AdWords for customers from a marketing standpoint. And he aggressively does this, and got a cease and desist letter from a lawyer out in California that represents a competitor to his client, his firm's client, and said, you know, we noticed that you're buying up our AdWords and it's illegal and this and that. He didn't cite a case, didn't cite a law, you know, so we said, well, this is a novel legal argument that you're making here in your letter, but it's not based in reality, and so until it is, you know, feel free to bid against. I don't think you quite understand how the internet works, you know. I noticed you still list a fax number on your letterhead and no email, so maybe it's time for you to get out of the internet threat letter business. Okay, so again, this is an emerging area. We talk about meta tags. All right, you talked about AdWords, but what about in your website itself, buried in the deep back end parts of it that only the search engines see? You start to put your keywords as your competitors, and so you're trying to get their traffic towards your web pages. So far, meta tags have not been prohibited. So you're not prohibited from using meta tags. There's been some attempts to get some legislation on that, but it hasn't gone forward. And so you can use them. What you can't do is in the actual front end of your website, things to create confusion amongst consumers that actually land there. The second thing here, dilution. You can still see dilution even in the online world. And so there was a pretty good-sized case here with Hasbro over the Candyland.com website. And ultimately, this isn't going to just be over dilution. If you have a trade name, then you can get the domain. All right. But again, you still have to pay for it. You don't get it for free. All right. But you can sue for the rights to that. Okay. Licensing. What is a license? Well, a license is an agreement that permits the use of a trademark, copyright, or patents anywhere, not just on the internet, but anywhere that can be owned. And so a license is still necessary. The owner is the licensor, the user is the licensee, and the terms of use are delineated in an online license agreement. And so when you talk about a user agreement, this is what you all read so very carefully every time you install software and every time you visit a website. So the first thing you do when you hit a new website, right, is you go to the legal notice page and you read the terms of service. Make sure you understand that by clicking on this website, these are the terms of use, right? Oh no, you've never actually read that? Okay, well, no one else has either. But buried in those terms of use would be the appropriate ability to use copyrighted material. You say, I'm not using copyrighted material, I'm just visiting your website. Well, go all the way back in the beginning of sort of computer law, okay, and it was very well settled at that time that copying an image or a trade name onto your computer's RAM was considered a copy of that work for copyright, trademark, and so forth purposes. So when you look at a website, what happens to those images? Where are they? I mean, first of all, they're in your computer's RAM, right? They're in there. But they're also where else? They're saved in your cache, all right? So that file is now saved on your local hard drive, just in case you ever come back and the site will load faster then, okay? And so the idea, somebody say, well, I use safe search in other ways. Well, okay, then it's not safe. But in the general use of things, you're not only looking at it in RAM, but you're also saving it to your hard drive. So go back to old school copyright, computer copyright law. Is that infringement? Well, it is unless they've granted a license, okay? So it's important for that website and putting it out there. And I guess I would probably argue to the judge, I don't think you understand how the internet works, okay? You have to, in order, they put this website up. I think that's kind of a fair use in order for me to look at it, okay? But that's used to control the types of people that are allowed to use a website. So this is used in terms of creating private areas that only members and so forth. So someone who would try to hack in would be violating the terms of use. All right, who's got case 5.2? All right, what was going on? Oh, okay, perfect. Any, these aren't? No relation, okay. Oh, that's not the V of the thing, so it's not the last name of, that's like his middle initial or something. Okay, all right, what was going on in this case?
They had a restaurant called Buddha Bar in Paris, and then they allowed the little rest 12 in New York to use their trademark name.
Okay, what was the trademark name?
Is the Buddha Bar.
The Buddha Bar, okay. All right, well, I'm just trying to figure out if this is a fanciful word or something that's, other common or...
It sure looks like a Buddha Bar.
Okay, all right. So it's in Paris and New York, and it's Buddha. All right, you expect maybe like New Delhi or somewhere, but okay. So they licensed it to be used in New York. Okay?
And they allowed them to use their mark, and then they used it on their website, but there was like, that you could tell the difference between, and then the George B. restaurant or whatever, then changed his mind and didn't want the little rest 12 to use it anymore.
Where?
In New York.
In New York at all?
So,
Okay, all right.
But then they kept it on their website, so then they were...
Okay, so they had a license to use it in New York, and they used it in New York, and they've used it on the internet. And then the Paris branch says, okay, we no longer want you to use it in New York, and they stopped using it in New York? They didn't.
They kept it on their website.
So did they keep it on? Did they keep that as the name of their restaurant also? Okay. All right. So how's the court rule on that?
They originally denied the plaintiff's charge, but then a higher court reversed.
Okay. So what's the court's reasoning at that point?
They said it was trademark infringement.
Okay. So you kind of have to take their word for it that the cancellation of the license was within their authority to do. Okay. So there must have been some term that allowed them to do that. And so they exercised their right. They canceled the license. And so at that point, the New York branch has to stop using it in New York and online, right? And if they don't, then we're right back into you don't have a license, you can't use this trademark, it's registered. And if you use it, they will suffer irreparable harm and consumer confusion if the use is continued. Now, here's a term that I want to talk about here for a minute. Irreparable harm, okay? Why do you think the court has to find this particular element is present? Okay? There's a particular reason why they use the term irreparable harm, especially in the trademark area. What is the normal element of damages or method of restoration when a person wins a private lawsuit? What do we normally give them? You get in a car accident, you're hurt, what do you get? Which is what? Money, okay? Right, you get money damages. Is that what this guy wants? Money damages?
He wants specific performance.
He wants an injunction, okay? Now, an injunction is different than money. Now, he might get some money, but what he really wants is for him to stop, right? Stop it. And in order to get an injunction, a judge has to find that the plaintiff would suffer irreparable harm if this is to continue. And if he can find that, then that's a precursor to an injunction where the judge tells him to stop. Did the judge grant an injunction then in this case? Yes. Okay. So the Paris restaurant is granted an injunction against the New York restaurant, and they are told specifically, take that down, turn off the website, take off the terms. Okay? So that's kind of how these things tend to play out online. Okay, let's switch gears for a minute. We talked about trademarks. Remember, there's three kinds of intellectual property. What are the three? Trademarks, patents, and what's the third? Copyright. Okay, so we're going to look at patents and copyright the remainder of our time today. So what is a patent? Well, a patent is a government-granted monopoly to use an invention that you created. Okay, and the idea is that you are given this government-granted monopoly for a limited amount of time, and then after that, everybody gets to use it. Okay? And so you get a head start in the market to develop this, to create the market, to sell it, to profit off of it, and then after that, everybody else gets to use your design. And so it's a head start. Now, normally, legally, in business law, when we talk about a monopoly, it's a bad thing, right? I mean, it's prohibited. It's illegal to engage in monopolization in a market. It's not just a fun game, okay? It's illegal, and you can't do it. But in this case, the government doesn't just allow it; they create it, and they give it to you. So it's a little bit opposite of what you would normally think. Why does granting someone a monopoly create and foster innovation in a society or in an economy? What is it about this that is going to actually, because that's the goal, right? Is the goal of the patent system to make inventors rich? No. Is the goal of the patent system to create monopolies and keep people from using other people's inventions? No, that's not the goal. The goal is a societal goal to advance everyone through new innovation. So how does granting one person a monopoly, granting one person the ability to get rich off his inventions, accomplish the goal of society to advance in its knowledge and technology and so forth?
Well, it kind of forces other people to come up with something better. Come up with it.
Okay, so it kind of competition amongst inventors, and don't steal that guy's stuff and he won't steal yours, and think for yourself. So sort of individual creativity is one element, sure. What else? Eric, what do you think?
It's to protect because you want to foster, people aren't going to spend a lot of time and money on inventing something if they know it's not going to be protected. If they know somebody can just come and steal it, somebody who might be in a better ability to make a profit.
Right, right. This is about motivating inventors. Okay? Motivating inventors. How much invention occurs in societies that don't have this? Name a society that doesn't have this. Like the biggest country in the world. China, right. Okay, China doesn't have this. If you invent something in China, who owns it? China. Okay? If you invent something in Russia, who owns it? Russia. Okay? And quick. Name something that was innovated in Russia. Okay? Name something that was invented in China. Quick, go, do it. You can't. There isn't anything. Why? Now, what do? What are they very good at? Stealing other people's inventions. Absolutely. Did you ever see the Russian space shuttle? It looked exactly like ours. It was ours. Okay, they stole it. You ever see some of these fighter jets that the Chinese Air Force has? They're ours. They stole them. You ever see the knockoff iPhones and iPads? They stole the design. There's no innovation in a society that doesn't protect inventors and intellectual property rights. So even though we go through a chapter like this, and even though online and bloggers and everybody else will tell you this system is broken and it's terrible and all this, it's really not terrible. Okay, I mean it's actually been working. It is abused badly. It is badly abused. All right, no question about that. But let's don't lose sight of the fact that we're still inventing stuff in 2013, and really cool, awesome stuff that gets smaller and smaller and does more and lasts longer and actually has batteries that can get you through the day. All right, so which is not the same, could not be said. My first PDA, all right, let's see, was a Palm 3. All right, it was a Palm 3, and it was about that big. All right, like a graphing calculator size, and it had AAA batteries. you had to change. All right, there was no plug it in. Those lasted about a week. All right, you had a little stylus. There was no you couldn't do it with your finger. You had to do it with the stylus. It was awesome, and it was revolutionary. All right, before Steve Jobs was revolutionary, and those kinds of things evolved over time and became everything in one thing. And why is that happening? Because people can profit off of that. All right. Now, your patent is not on the invention itself. Your patent is on the design of the invention. Your patent is not on the idea. It's on the design. Okay? So a few things that you can patent. Can you patent software? Well, unfortunately, yes you can. Okay? I'll give you an example of things that can be patented. Okay? Apple has patented this. Did you see how the screen went down and when I got to the bottom it kind of bounced? They patented that. Okay? that mechanism, that slide mechanism that refreshes the screen and goes and checks my email, and that's patented. Okay? When you look at the types of things that can be protected, it's very granular. Okay? So there are thousands of patents associated with this device. And the tech companies go at each other's throats over this stuff. Okay? And you've seen Samsung and Apple battling it out. And what's bizarre is they also license everything to each other too. So they're partners and blood feud enemies at the same time, and yet that somehow nobody thinks that's weird. Okay, then eventually they'll settle and send about roughly the same amount of money back and forth, and everybody will be happy. All right, so your patent's for design, and you get 14 years. Okay, there are certain circumstances you can extend that, but you get 14 years of protection on your design. Yes.
When you see something that says patent pending, what's in my mind, the first thing that would make sense would be that, they're working on getting a patent, but is that really the case?
It means it's been filed, and they're waiting for it to be approved. So
you can still use something?
Mm-hmm. You're still protected. You're giving notice that we are claiming rights to this, but it's not like trademark and copyright where you have it automatically.
What if someone else had filed before them and it just hadn't come through yet?
Then they're toast.
Then you're infringing?
Right.
And once theirs comes
First to file is assuming you actually get approval, the first to file is going to be the one, okay? So what is patentable? Well, it has to be novel. It can't be obvious, okay? So you can't go through and say, I'm going to patent the wheel. It's a round object, the spokes, and a hub in the middle. You put your finger in there and you can roll it, okay? That's obvious, okay? You can't. It can't just be a combination of existing things that anybody could put together. I'm gonna patent this Lego, creation. Okay, well, if it's totally useful, maybe, but it has to be novel. And a lot of patent challenges are on that kind of thing. You might say a lot of the user interface buttons and so forth on the iPhone and the different Android devices. You would say, boy, those look awfully similar. How is it that they're able to do that, to copy each other? Because it's just obvious stuff. Look, I made a rounded rectangle. I put a little shadow underneath that thing. Okay, can you? Apple has actually tried to patent the look of app buttons. Okay, so the size as a rounded square, the shading, the shadowing, the gloss. If you look at them, they all look the same, even though there are thousands of different app developers out there. How is that possible? Because they have trademarked that and patented that particular look and feel, that design. Okay. All right. So what is patentable? Anything that's novel. Almost anything is patentable. You cannot patent the laws of nature, natural phenomena, or abstract ideas. Okay. But I'm going to patent gravity. Okay. So what about the sequencing of the human genome? Okay, so this is, on one hand, natural phenomena, okay? This is just like where our genes are. But on the other hand, somebody's got to do that, and what's the payoff for having done it? Okay, you do it, you figure out what genes do what, and you get published and famous, but I got to, my baby needs shoes. I got to get paid for this work at some point. It's not cheap to sequence the genome. I mean, last time I tried, it was hundreds and hundreds of dollars. And I didn't get anywhere, So tell me how that fits into this. Can you patent that?
You could maybe patent the process or the actual work itself.
Okay. But can I protect my findings? Because that's really the valuable part. Once it's known, it's known. It's like knowledge.
Can you copyright it if you put it down on
Copyright it?
paper or something?
You can't copyright a formula or a recipe. It's just if that's just a combination of existing items. A list. You can't copyright a list. So, yeah, that's the problem. Now, go back to the goal. What is the goal? To advance society. How does it advance society if we hide this kind of groundbreaking data and information behind government-granted monopolies? Hard to argue that one, okay? So we're getting harder and harder. The Supreme Court will decide that this next term. That case is right now before the Supreme Court as to whether or not you can patent the human genome. To me, that's just gross. I mean, come on, you can't do that. I mean, you can't. That's absolutely unconscionable. How many people are going to die of curable diseases in the meantime of your 14 years of trying to profit off of having found it? That to me is just woefully unethical. All right, no matter what structure you analyze that. All right, who's got 5.3? Okay, what's going on in this one, Julie?
So Teleflex is suing KSR because Teleflex has a license for this patent. They call it the adjustable pedal with electronic control. And basically what that is just they combine the electronic sensor with the adjustable automobile pedal, and its position can be transmitted to a computer that controls the throttle and the vehicle's engine.
So it's fly-by-wire. Okay, so their thing is when you push the pedal down on a normal car, that pedal is physically connected to the throttle on the engine. Okay, you understand there's a wire that actually, it's a pulley system, and it's actually opening the gauge. What they created was an electronic system, so the pedal is purely digital. Okay, so it's sending a signal to a computer is then interpreting that and sending it on to the computer, and the computer has a servo that's opening up and closing the throttle, right? That's kind of what your understanding is? Okay. So they patented that system, and they've got a license for it anyway. And so why are they suing the other company?
They're suing them, well, they didn't really say why patent infringement. But KSR then contended that patent couldn't be created because the analysis was obvious.
So they're saying, I mean, we have this like everywhere. I mean, remote control airplanes you can buy for $50 in a store have the same technology. This is too commonplace to be patentable. All right. Now, what's interesting is once somebody invents something and puts it into the stream of commerce, then all of a sudden it's obvious, right? Oh, well, yeah, I mean, anybody could have done that. Yeah, but you didn't, I mean, if it was so obvious and people are buying it like crazy and now you want to market it, why didn't you, okay? So there's always that problem is that after the fact, everything's obvious. And courts wrestle with that question all the time when that's the case, okay? So how does the court come out on this?
Well, they took it to the district court, and the district court agreed with KSR and said, yes, it was obvious, but then it was appealed to the Court of Appeals, and they reversed it and said it was not obvious, and then KSR took it to the Supreme Court, and the Supreme Court reversed the appeals court decision, and said that it was obvious and erroneous.
Okay, so they said, you know what, all you really did was combine things that already exist, and now you're claiming that you invented something. Now, what's the problem with that?
Yeah, everything has to be based.
That's right. Every invention is just the combination of other things, right, into something new and novel. But that's the key, is that it can't just be using things for what they've always been used for and now all of a sudden claiming protection. It has to be truly novel, okay? Now, how novel is novel? How different does it have to be novel, okay? Well, that's a good question for a judge. Now, my argument would be that patent and trademark cases should never be sent to juries. If it was up to me, I would change the system completely and we'd never have jury trials over patent and trademark, because normal people do not understand this stuff, okay? You, after having this chapter, will not totally understand, even to the point where you would be able to knowledgeably sit on a jury, okay? You're going to have a basic understanding of it, enough to know when it's time to engage an attorney to tell you what to do in those cases, when it's time to protect a mark or something in the business that you're involved in. But you're not going to have enough knowledge after two days talking about this for you to go in and actually file the paperwork and prepare the patent application. By the way, neither do I, okay? In order to be a patent attorney, you have to, first of all, have an engineering degree, an undergraduate or a master's degree in engineering. Then you have to have a law degree. Then you have to pass the normal bar. Then you have to pass the patent and trademark bar, which is a second bar. It's the only area of law that's treated that way. Okay, so if you like engineering and drawing but you don't, you're not actually that creative, patent law might be a great option for you, because you could, become very wealthy. Those guys do really well because there's so few that actually fit those qualifications. So if you're wondering what to do with your career, a new option for you. All right, a little bit of school involved, but and you're going to have to get another degree, an engineering degree, but those guys do very well. All right, so in order to be patentable, it's got. Now, does the court give us any guidance about what it takes to be novel, or what? Are they just kind of treating this in the negative, saying it's not novel enough?
Well, their reason for ruling that way was that there's a little difference between what existed in previously filed patents, and so the Just Electronic it was just basically that was previously.
Okay, so they're saying there was so much pre-existing patented stuff, you really didn't create anything on your own, okay? Which is a pretty legitimate concern, yeah.
So how can, like, a lot of those car companies, like, you see the commercials of, like, the newly patented whatever, like windshield wipers that go faster when it rains harder, like, how can you patent something like that? I feel like it's not much different.
Well, the end result may not be much different, but you're not patenting the end result. You're patenting the design that got you there. So there's all kinds of sensors that they've put into it. By the way, one of the very first, most groundbreaking patent cases was about the intermittent windshield wipers. Okay, and this guy goes in and he pitches this to all the major automakers, and every single one of them told him, that's the stupidest invention we've ever seen. Get out of here. We're not paying you a dime. And then they all, obviously, after the meeting went, holy cow, we totally have to do that, okay? And they went and they basically ripped off his complete design, put them on their cars, and never paid him $1. Okay, so he sued and sued and sued and sued for years and years and years to finally get through the court system, and he ultimately won. And what's cool is by the time he won, they were on everything, and so he won big, and probably bigger than he would ever have contracted for in the beginning had they just bought it from him. So. But that was one of the very first, most famous cases of most obvious infringement. All right? So what does it mean to violate a patent? Well, again, we call it infringement. Anytime you manufacture, use, or sell another's product or design without permission. Product infringement occurs even if not all of the features are copied. If you just copy enough of it. If it's a process patent, then all the steps must be copied, okay? Process infringement, somebody said, well, I'm going to invent a new business model, and I want to patent the business model. Can you do that? Well, as a lawyer, I tell them, yes, you can patent a business process. That is true. What value is in that? Well, not all that much, because in order to be infringed upon, every single step has to be copied. And so if you have a 10-step process and they change step 8 and get to the same place by step 10, then you don't have infringement. Your remedies, you can get an injunction. It's not automatic. They have to show that key is what? Irreparable harm, okay, by continued. They actually prefer now royalties be paid. Why do you think that injunctions are no longer a preferred remedy for patent infringement? Go back to the goal. What is the goal? It's to advance. If this invention is out there and it's really useful to society, that's a good thing. So what the courts have done, it's kind of interesting, they sort of flipped it over and they said, oh, company, you wanted to use that patented invention and you thought that was valuable enough to steal and put on your vehicle? Great. Well, we assume that what you meant to do was pay them royalties, and here's the amount you're going to pay. And so they just write up a contract and impose it on the other side and say, you're going to pay it. You say, well, know what? We changed our mind. We're not going to use it anymore. Too bad. You're paying. Okay? And so now at this point, you might as well leave it on the vehicle. Okay? And plus attorney's fees and costs, which in a lot of cases ends up being equal to or exceeds actual damages that get awarded. Believe me, the lawyers always get paid. All right, because judges are lawyers too. So a little bit of backroom politics there. Okay, let's switch gears for a second. Any other questions about patents? I realize it's kind of a high-level overview, and we don't intend to go a whole lot deeper with that, but that's patent law. Okay, copyrights. A copyright is for intangible property right for something that is written, something that you created, wrote down. It has to be fixed in a durable medium. Remember we talked about it has to be reduced to some recorded fashion, like an audio recording, video recording, or written down by hand or typed out on a computer. All of those things, as long as it is capable of reproduction. That's the issue. Is it capable of exact reproduction? And if it's in some kind of medium that can be reproduced, then it is copyrighted. So if you've seen those, you probably haven't seen it in person, but maybe a picture online where somebody's back window is really dirty. And somebody has come along, and rather than just, the old wash me, they actually do like a work of art in the dust of your window on the back of your van. Could that be copyrighted? Yeah, it's fixed in a durable medium. Now, you say, well, the minute I flick on my windshield wiper, that dude is going away. All right. Well, yeah, but we could take a picture of it, and then it would truly be fixed. So as long as it's there, it's protected. Now, once it gets wiped out, then we're gone. But it's not the idea. Yes, there's actually some case law on that. Graffiti actually is protected. Now again, you've got a trespass issue there, and I think that your rights to the copyright of that are superseded by your illegal activity in tagging someone else's property. But and there's a whole movement out there right now just asking the question, is graffiti art? And I think overwhelmingly, at least legally, the answer is yes. I mean, there's nothing about it that doesn't fit the definition, except that it's not on you don't own the medium, all right? Well, that would be kind of an interesting thing. The guy comes out to paint his wall that's been graffitied, and the artist sues him, for destroying his copyright. I don't know. Or you take a picture of your own house that's been tagged, and you get sued for copyright violation. I don't know. That could be interesting. Maybe I'll make that into a unit test case. I don't know. All right. So intangible property automatically granted. Do you have to file to be protected under copyright? No, you don't. Can you file? Is there some mechanism to file? Yes. Yes, you can. We'll look at in a minute why you might. And what you get is the life of the author plus 70 years. Okay? So you've all sung out of a hymnal, right? And on a hymnal, when you're looking at a song, what's down at the bottom? Okay? In the little footer you see the author's name, and what else? What other information do you get about the author?
Year of
Birth and death. Did you ever wonder why? Did you ever think that's kind of some odd information to put on there? Why not put like where he lived and if he was married and how many kids he had and what his occupation was, and why would we put his years of life? That doesn't make a lot of sense. And then you'll see like Ron Hamilton, 1950 dash, okay? So he's still alive, right? And you say, well, in that case, why do I need to know that information? Because a copyright exists, and he's the author, so he has the copyright, and so it exists for his life plus 70 years. So if there's a date of death, and it's more than 70 years, then the assumption is, not completely reliable, but the assumption would be that that's no longer protected by copyright. So this is very important for people who do arrangements and who want to use works in making a recording and things like that. Because, like for example, for Maranatha, if we send out a group and we record that group and make a CD to sell, we've got to make sure that we have the rights, we obtain a license for the use of all of that music. And so we actually then end up paying royalties on those, and that's all a part of the process. So you get it for life plus 70. What is protected expression? Well, if it's fixed in a durable medium, the ideas aren't protected, and a compilation of facts is protected, but the facts themselves are not. So let's say we have an infographic. Have you ever seen an infographic? Okay, I tend to like those. They're getting lamer and lamer, though, as more people get into making them. But you see an infographic. Are those facts protected? No. So if I want to go out and tell somebody a fact I learned in an infographic, I'm not committing copyright violation. But the expression of it in a graphical form, that is protected. So if I was to copy that and use it in an illegal way, I would be guilty of copyright infringement. Okay? Yeah.
So with that Human Genome Project, if you wrote a book about it, the book would be protected, but the ideas and facts about the genomes aren't, which is what he's trying to get in court is.
Well, and again, we're talking copyright here.
Yeah.
What was protected in the trademark side is like a trade name. What was protected in the patent side is the design. Okay? So again, we're looking at three different facets of intellectual property. If it's the expression that we're talking about, then it's going to be a copyright issue. Okay? So poems, songs, books, things like that can all be copyrighted. What is infringement? Anytime the form or the expression is copied, it doesn't have to be in its entirety. There are penalties, damages, and even criminal action is possible under copyright infringement. When is criminal action available? When you do it for commercial gain. All right, so if you crack a computer software program and upload it to the Pirate Bay, then yes, you are probably not only civilly liable for that, but potentially criminally liable as well. All right, that was the Napster situation, is that they were commercially profiting off of that. Okay, the fair use exception. One line on this really doesn't do it justice. We'll talk more about this in one of our ministry law lectures. The fair use exception exists to say that you can actually use someone's copyrighted work for certain uses that benefit society. So education, or on the news, you want to say something about it, or for research, or for editorializing. So someone writes a review of a new book that came out, and for the New York Times they write a review, and in order to give you the flavor of the book, they take an excerpt from the book and they put it in the article. And they say, here's this passage, and this is an example of how stupid this book is, never buy it. Now, when you have a negative review, that's when the lawsuits come. All right? And one of the things that they always claim is copyright violation. But a fair use is, without permission and without paying a dime, you have the right to use that work. Now, it has to be limited. In education, you can't just say, oh, it's educational, so we can copy the entire textbook and pass it out to everyone. No one has to buy the textbook. Now, you would all be happy, right? But the textbook company would be sad. But did you notice that I gave you on the website Chapter 2 as a PDF? You didn't have to buy the book. Now, is that copyright infringement? No, it's fair use because it's less than 10% of the overall work, and it's for educational use. And the idea is actually to encourage you to buy the book, not to discourage its purchase. Okay? How do I give notice that I am claiming copyright over a work of my own creation? Well, at the bottom I give you the usual amount of information that you want to put in the footer, okay? And it's the little circle C, and the date, and then the owner, all right? If it's a business, it's a little different. It's not life plus 70. If it's a business, I think it's, what is it, 110 years or something like that? Just straight up 110 years, I think. All rights reserved. Why do you put all rights reserved? You don't have to. I just put it on there because it kind of sends a message of, no, I'm serious. I'm really claiming this. Okay, and I will give you permission, but you need to come ask. You know, those kinds of things. So you want to put that on there to give notice. Now, do I have a copyright if I don't put this on there? Yes. Do I have to file it with anyone in order to have the right to put this on there? No. I have the right to put that on anything. So why do it? If I have it without it, and I don't have to do anything special to put it on, why do it? Well, because if I have given notice, then there's going to be enhanced damages, okay? Because I'm able to show that there was no excuse, they knew that this was copyrighted material, and they never contacted me. So it has an enhancement to damages. All right, what about copywriting digital media? Well, the problem is it can be easily copied. And as I mentioned before, anytime a copyrighted work is downloaded and stored, even in your RAM, or on the hard drive, then there is infringement. And so any kind of downloading of unauthorized works is considered to be infringement. And you say, well, it's just in the RAM. It's not even saved on my hard drive. That's not good enough. The Copyright Act of 1976 is what laid that down. So when I said back in the early days of computers, I'm not lying. I mean, that is way back in the early days of computers. So it was pretty obvious coming into the late 90s that the Copyright Act of 1976 wasn't cutting it anymore, and we really needed something to do better. And so the Digital Millennium Copyright Act, DMCA, comes out. Like it or love it, hate it, whatever. You know, people mostly hate it now. But it gives us something, okay? And what the DMCA says, it's a very balanced law, and it says copyrights online are still protected. It outlaws copying. It also outlaws creating devices whose sole intention is to break copyrights. So back in the old days, the Wild West before this, okay, you had people making DVD players that had 2 slots. It was great. You rent a DVD from Blockbuster Video. There used to be a company that was Blockbuster Video, and you could rent a physical disc, and you put that into one slot, and then you had a second slot. You put a blank disc in there, and you hit record, and whoop, and it just cracked all the encryption, copied it over, burned a new DVD. You take it back, you own the DVD. Okay. The only purpose for that, I mean, that decryption algorithm that was in there, was to crack DVDs, okay? People were writing software that could crack the PlayStation and Xbox encryption. So I don't know that you can do it on a PS3, but on the PS2, you could crack one of those discs and burn it to a new DVD. And then there was, of course, software for simply cracking computer software and applications. So if you got Photoshop, and they could crack that. So the idea is, if you have created a device or software or a platform whose sole purpose is to circumvent copyright restrictions, then you have committed a crime, and you can also be held civilly liable. So who's the guy recently that's like the poster child for copyright infringement? It used to be Napster guy, but now who is it? His first name's Kim. His last name is .com. Okay, believe it or not. And so Kim.com. And does anybody know what the website was that he's? Mega Upload, right? So the Justice Department took a bit of an interest in that, and his whole thing was file sharing and on a massive scale. So a couple of things that he did wrong with his first attempt. He had deduplication. Does anybody know what deduplication is? Dropbox uses it, and Mega Upload used it. You know what it is? You know what it is, Matt? Deduplication? Okay. If I upload an MP3, okay, of the latest Patch the Pirate song, and Except, Patch the Pirate was a pirate before pirates were cool, way before they were cool. And so I get the latest Patch the Pirates MP3, and I upload that to Dropbox. Dropbox on their end is unencrypted, and it analyzes that file and says, oh, somebody else already did that. So to save space on our servers, we'll just point his link to this version and not save it twice. So it's deduplication. There's no duplication. Well, Mega Upload did the same thing. So they would get a DMCA takedown, which is the takedown notice of a rights holder, sends an email describing the link that they have found to infringing material on your website. And the idea is, if you are the server provider, you are protected. You cannot be charged with infringement if you promptly respond to a takedown notice by, what? Taking it down. Okay. Now, there's a downside to that because content holders are not always right. You'll have there's story after story of Viacom Media, which happens to be particularly aggressive at DMCA notices, and they will routinely send takedown notices to YouTube and to take down stuff that they themselves posted. So they have these computers that go out and find their material, and so some Viacom branch will post The Daily Show on YouTube, a clip of that, and that's a Viacom property. So then the Viacom lawyers who run their stuff will search YouTube, find that clip, and issue a DMCA takedown on themselves. Okay, so it's really efficient business practice there. And so they're not always right. Happy Birthday gets tagged all the time. So people singing Happy Birthday and putting the YouTube on there, and then the people who own the copyright on Happy Birthday, literally there is such a thing, will issue a takedown. And that's not right. That's clearly fair use, okay? But the server owners don't analyze the takedown. They just take it down and send you an email saying, this is why we took it down. Do you dispute it? And if they say, yes, I dispute it, I have a right to that. Then the server company has a choice. They can either put themselves in the crosshairs and put it back up and say we believe them, or they could say, well, looks like you guys have a disagreement. Work it out between yourselves and let us know what to do later. What's the problem with that? In the meantime, your content is what? Gone. Okay? So it very much favors, it puts it on the ISP, that's the server provider, to take things down quickly and never put them back up, essentially. And so that's the DMCA right now. So what Kim.com and Mega Upload did wrong with deduplication is that a rights holder would send a DMCA takedown, and he would take down the link to the one version of that file, but with deduplication, what could he have done? He could have taken out the entire file for everybody that had ever uploaded that MP3 or that movie or whatever it was. But he didn't. He would just take down the one that they were told. And so that got him in a lot of trouble once he finally got to trial, and that didn't look real good, to the Justice Department either.
I was just thinking, how do the music producing companies get around allowing you to take a CD and you can legally rip it right to your computer and put it on your phone or your iPod or whatever?
They hate that, by the way.
Yeah, but how are they allowed to do that, but you can't do that with a DVD? What's the difference?
The difference is the technology. Because DMCA says cracking encryption is a violation. And if audio CDs were encrypted, you would not have that ability. So, because the technology that's now ubiquitous everywhere doesn't have any way to handle encryption. Whereas a DVD player, it was written from the beginning. They were invented from the beginning with encryption ability. And so that is the difference. And it's a strange difference. And it's not a very hard encryption to break with a DVD. I mean, a free Handbrake will do it and some other software. But, and by the way, all of that gets, the way Handbrake and some of the other ones get around it is they're free. So they're not commercially profiting off of that. If they were, you'd have trouble there. Okay, so Kim.com shut down with media, what's it called? Mega Upload, yeah. And so he relaunches 2 days ago with the new Mega, all right, mega.co. Hopefully it's blocked on campus. And his new thing is you get 50 gigs of space. So Dropbox will give you, I think, 2 to start with and let you add more through convincing your friends to join. I'm up to like 9.5, and I'm so proud. But he'll give you 50 gigs of online storage for free. And his new service does two things differently. One, it's encrypting everything on the way up. So he has no way, their company has no way of knowing what you stored on there at all. Okay? So it's encryption on the way up. And secondly, no deduplication. So if this guy puts a movie up there and this guy puts a movie up there, it just takes up twice the storage, and he's good with that for now. Okay? And so that's going to really help who when it comes to a DMCA takedown? Is that going to help the user? No, because in order to share this link, he's got to put it out there publicly and associate himself with it, and then everybody's going to know who he is. But who does it help? It helps Kim.com. Okay, it helps his service survive, because they can say every time we get a takedown, we will take down that file, and they'll do that, and they did that with the old one too. But he has no way of knowing anything about his users' use of his platform. And so through that, he's thinking that he has found some loophole in online. And I guess all I can say about that is we'll see. Okay, we'll see. So the Napster case was peer-to-peer sharing. What do we call that now? That is essentially torrent. There was no BitTorrent back then. Now there's torrent sharing. Is torrent sharing illegal? No. Is it unethical? No. It's just a delivery mechanism. Lots of freeware and large files, academic journal files, and things like that are available and appropriately can be distributed that way. You can get much faster download speeds, I guess, from a torrent download than you can from one server, because you have a whole cloud of computers that you can draw from. But it's used primarily, I would say, for infringing content and sharing that. Now, what's the problem with torrent files? Are you anonymous when you download torrent files? No. Your IP address is out there and distributed out to the cloud. And so there are lots of people, in fact, I've had former students that get these really nasty, scary letters from rights holders. Most recently, the movie, what was that movie about the bomb disposal guy?
Hurt Locker?
Yeah, the Hurt Locker. Okay, so the Hurt Locker was not a major motion picture studio film. It was like an independent film. And the people that made it were very aggressive at tracking down pirated versions of it online. And they sued everybody they could find. And they sent these demand letters. And for every person that they could find, their demand was for $2,000. But you're selling this movie for like $10 in the bargain bin at Walmart. How have I damaged you $2,000? I don't know, but just give me $2,000 or we're suing you. Okay, and that shakedown worked. And in fact, they made more money on settling lawsuits after the fact than they made on the release of their award-winning movie in the first place. All right, but they're one of the only ones that have ever made money on that. And right now, I'd say the legal system is waking up to the fact that this is abused royally. Is basically a shakedown. A cloud network, that's like Dropbox or Amazon EC3 or those kinds of things. What about Grooveshark? You familiar with Grooveshark, how that works?
Then you enter the title of a song, and then you basically just have it saved. All you have to do is look through some ads, kind of.
I don't even know if there's ads, are there? I mean, I know with
There was
Pandora.
on the side of the bar, but there was never that interrupted your song.
Right. And where does the music come from? Users that upload it, okay, and tag it and identify it. So you say, well, this is like just a new version of the Napster case. Well, the difference is Grooveshark is paying royalties. And you'll notice that there are certain artists out there that just absolutely refuse to allow their stuff to be on there. But for the most part, those that are with major labels, the labels have negotiated with Grooveshark and made a royalty payment scheme. And that allows for people to discover their music, which is actually kind of a good thing, right? I mean, if you're trying to get noticed and discovered, isn't it good that your stuff is popular? The Gulkin stuff and the Pettit team and those kinds, every one of their CDs is on Grooveshark. So again, you can't download it, but you can listen to it and stream it. And every time you stream it, royalties get paid back. to the rights holders, allegedly. I asked Will Gawkin about that. He didn't know anything about it, so it must have been whatever label he's with. Okay, so that's trademark, copyright, and patent. What about, we just have this secret. How do we protect the secret? Well, trade secrets are confidential information. There's nothing filed with the government. It's anything. Customer lists, formulas, pricing. Can those things be trademarked? Can your pricing be? No. Can your customer list? No. Can your formulas? No. There's none of the three that we've talked about that will protect any of that information. So how do you protect it? You don't tell anybody. Okay? The formula for Kentucky Fried Chicken and for Dr. Pepper and stuff, where is that? It's in a vault under lock and key. Only certain people know certain parts of it that are absolutely necessary, and those people will be killed if they ever tell anyone or whatever. And so they're protected by physical security, first of all, and then by law. So a theft of trade secrets is a federal crime. Online, employees, unfortunately, can easily email out information. I've dealt with this. I had a case down south with one of the companies, just one of the secular cases I had, where this guy was a technician for an IT company that went out and did, for small businesses and stuff. And he left, and he had signed a non-compete. But when he left, he went and worked for another firm, and he went to every one of his customers, and he said bad things about the old company, lied about them. He said they were going out of business, and so they needed to move their business over to his company. Well, what's the problem with that? Problem is he stole the customer list, he violated his non-compete, there were all kinds of problems with that, and legally then you have the right to enforce that. But it's certainly made a lot easier. Internationally, we now have treaties and conventions. The Berne Convention was the first back in the late 1800s. It's been largely replaced by the TRIPS Agreement, which says each member country has to respect the intellectual property rights of members of the other countries, which makes sense, right? So that's where Europe and the United States and Mexico and most of the nations of the world have signed on to the TRIPS Agreement and have said, we will respect your intellectual property rights. That's how the case that she read, which had a Paris company and a New York company fighting over a trademark, well, that all falls under the TRIPS Agreement. And then there's the WIPO, World Intellectual Property Organization, and they give you a method for dispute resolution internationally. And then the Madrid Protocol says a U.S. company can submit a single application to register its trademark with 73 different member nations. So rather than having to file all over the place, we now finally have a unified system where a single application will protect you everywhere. Okay? Single application will protect you everywhere. Okay?